Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco, and for more than 20 years now I've helped clients file Chapter 7 and Chapter 13 bankruptcy cases. In this video, I'm going to talk about when life happens during the Chapter 13 bankruptcy. Here's the situation. You've been in Chapter 13 for a year or longer and the cost of living has gone up, but your planned payment amount has stayed the same. It's getting harder and harder to come up with the same amount of money each month in order to make that planned payment. Or you've suffered a job loss and it's now impossible to make your planned payment. Life is not static. At the beginning of your case, you were required to file a budget with the court that was based on your situation and expectations at that time. But you and your attorney were not equipped with a crystal ball when you prepared and filed that budget. Life can change in dramatic ways that are not easy to predict. Families grow and needs change. The economy can change in ways that create financial instability, as can illness, death, and divorce. The Bankruptcy Code contemplates these changes and provides options for debtors in Chapter 13 who can no longer make their planned payment. Here are those options. Option number 1, modification of the Chapter 13 plan. You may be able to modify your Chapter 13 plan so that your required payment amount reflects what your current budget is. If you are paying secured or priority debt in full through the plan, however, you must still pay the amount that's required to be paid into the plan in order to satisfy those requirements. But if you're not yet at a 60-month plan, you can stretch your plan out to a longer period of time. You must file an amended budget with the court, as well as a proposed modified Chapter 13 plan, along with your motion to modify the Chapter 13 plan. You then need to obtain a court order approving the modification. The next option would be hardship discharge. This is a great option when modification is not possible and conversion to Chapter 7 bankruptcy is not ideal. There are some eligibility requirements, however. The first requirement is that there must have been a change in your financial circumstances, and that change must have been beyond your control, resulting in a situation that means you can no longer make your planned payment. The creditors must have received through the Chapter 13 plan at least as much as they would receive in a Chapter 7 bankruptcy. This is the liquidation test. So if you have non-exempt assets and you file Chapter 13 bankruptcy in order to protect those assets, your creditors must have received the amount through the Chapter 13 plan that they would have received in a Chapter 7 had the bankruptcy trustee liquidated the assets. The last requirement for hardship discharge is that modification must not be possible. This means your income must have changed so much that you can't afford a planned payment of any amount. The last option would be conversion to Chapter 7 bankruptcy. This also requires the filing of the motion, as does the hardship discharge. Every option I'm discussing today requires filing a motion with the court and obtaining court approval. Conversion to Chapter 7 is a great idea in many situations where modification is not possible, but it's not a good idea for everyone, especially if there are non-exempt assets involved. Non-exempt assets would be at risk if you convert to Chapter 7 because the Chapter 7 trustee can then liquidate them for the benefit of your creditors. Also, if any of your assets have gone up in value since you filed your Chapter 13 bankruptcy to the point where they are either now wholly non-exempt or partially non-exempt, they also would be at risk by converting to Chapter 7. One of the great things about Chapter 13 is if your assets go up in value during the Chapter 13 case, that's not a problem, but it would be if you convert to Chapter 7. A final reason why conversion to Chapter 7 might not be great for you would be if you need a Chapter 13 discharge in order to eliminate debts that are not dischargeable in Chapter 7, or eliminate a lien that you couldn't get rid of in a Chapter 7. For example, if you're stripping off a second mortgage lien as part of the Chapter 13 bankruptcy. Make sure you stay in touch with your attorney during your Chapter 13 plan and let your attorney know of any changes in your financial situation immediately. When things go too far, it can be really hard to fix them. Thanks for watching. Watch my other videos and have a great day.